Welcome to Talk Law Radio with attorney Todd Marquardt of the Marquardt Law Firm at marquardtlawfirm.com.
Welcome back to Talk Law Radio. I'm Todd Marquardt here on 930 AM The Answer. Podcasts everywhere, talklawradio.com, YouTube, and Facebook Live. So we've been talking about Texas guardianships and why they're so difficult. I do want to mention Joseph Warren at Financial Planning HQ again. He's one of our sponsors, and I just want you to call him if you want to avoid overly complicated financial products, because Financial Planning HQ focuses on creating comprehensive strategies that give you and your family the highest probability of achieving your goals. For a complimentary consultation with Joseph Warren at Financial Planning HQ, call 210-748-6699. That's 210-748-6699. Back to guardianship with Sharyl Mays. Tell us, after the attorney ad litem and the court investigator give the report, what's the next step?
The next step is to have the hearing to see if the guardianship is going to be ordered and approved. And, pre-COVID, it was in person. You had to go down to the courthouse. Now we have a little more leeway with the Zoom hearings, which is a little more convenient for us. But that is when everybody pleads their case in front of the court. We have to prove up the application for the applicant and prove that they're the best candidate for the situation. And the attorney ad litem comes in and pleads for the ward's best interest. And if we're on agreement, then easy. But then there's the contested situations.
Yeah.
And those have to be in person because they typically have to be on the record.
Right.
And then the judge has to decide at that point what is the best interest for the ward.
The ward is allowed to attend if it's not going to be a disturbance.
Absolutely. So one of the very specific questions on the certificate of medical examination that we have to get is we have to have the physician say whether they, even if they lack capacity, do they still have enough capacity to attend the hearing? And if they say yes, then we have to have the proposed ward there at hearing, and they have the ability to testify on their own behalf.
Right. And if anybody thinks it's a bad idea for the proposed ward to be there, you have to tell the judge and ask for the judge to excuse the ward.
Yes.
But like we were saying, everybody has to be invited, and the proposed ward has their attorney, the applicant has an attorney, and then if there's a contest by anybody else, they would also have their own attorneys. It's a complicated process. Everybody has to be represented, and then the judge will decide.
Yeah, and if it's contested to the point, we'll bring in experts and have them testify to the medical history of the individual. If there's bad spending habits, we can have a banker come in and speak to their bank records. There's a lot of experts out there that have a lot of knowledge on.
Right, or accountants to try and figure out where the money went.
Right. And in worst case scenario, if APS is involved, they will have to make a pleading or a report into the situation
Right,
as
Adult
well.
Protective Services. I've seen them come into the courtroom before also, because there might be other questions that need to be answered by the court, or orders to be made if there was a stealing of a incapacitated person's assets.
Yes.
Try and get that back by proving who did it and when it happened and how much money was there. Every now and again I hear about a disgruntled family member that says, where's the rest of the money?
We see that a lot, especially in the abuse of power of attorneys. Once somebody gets that authority, unfortunately, they decide, well, I have free reign of mom's checking account
Mm-hmm.
and start signing checks on her behalf.
That's a good point. If you can ask for a guardianship if you need to have the power of attorney suspended because of a bad power of attorney.
Right. And the court's going to ask that first. Do you have a power of attorney?
Mm-hmm.
And has anybody denied you authority to act on the person's behalf using the power of attorney? The court does not want to be involved. They have too many cases to handle right now.
Yeah. Or if there's two people that each have a power of attorney.
Yeah, and they'll look at when that power of attorney actually went into effect. Was it immediate upon signing, or was it upon the declaration of incapacity by a physician?
And was the second one signed with sufficient capacity?
Right, right. We've had a situation where a power of attorney was assigned to a second wife on the same day as a power of attorney was assigned to a son. One went into effect immediately, one went into effect upon the incapacity of the person. So at that point, at what time does the surviving or the spouse have to report incapacity of the ward, or do they just write out their power of attorney as long as they've got the authority?
Yeah,
It can get murky.
it does. Okay, so let's imagine that a guardianship is granted and the guardian takes control of assets and of scheduling medical appointments. What are some of the ongoing responsibilities that the guardian needs to be aware of?
So, on the personal side, they need to make sure that the person is taken care of, that they have shelter, food, water, the medical necessities that they need, that they're going to their physicians, that they have ample caregivers, that their medication is regulated, and just an overall wellness. But on the financial side, it's a little more complicated because then you have to go in and present your letters of guardianship. Once you're appointed, the court issues letters of guardianship. That is your golden ticket to the bank accounts. And so you have to write letters, go to the institutions, and it can be a battle for 6 to 9 months trying to get a bank to recognize the guardianship. And no two financial institutions' procedures are the same.
Right.
So what works for one may not work for the other. And that's why it's good to have a good attorney that is experienced in guardianship and probate to represent you, to help you with this, because it can be a challenge.
A court order and the golden ticket letters of guardianship isn't always enough. Sometimes you need a little bit of advocacy. And maybe just being on the phone for a long time, getting to talk to the right person in the right department and get those requests to the right person. You do that a lot.
I do that a lot. Just this last week, I was on the phone with IRS for an hour and a half just trying to get a tax ID for somebody. So it is time consuming, and as guardian of the estate, it is your responsibility to marshal all of those assets into one place if possible.
Right.
And manage it. You have to report to the court on an annual basis what you spent on the person's behalf and what you received on their behalf. And if the court doesn't like how you've done it, they're going to challenge your guardianship, and they're going to give you new rules on how you're supposed to act on this person's behalf.
Or they could be removed and replaced.
Yeah, and anybody, the annual account is a public record. So anybody that has interest into the guardianship can go and get a copy of that and request it and pick it apart.
Yeah, if you don't want your finances to be part of the public record, you should do power of attorney and take other measures to make sure that your affairs can be handled outside of the court, like power of attorney or living trust or other kinds of trusts as well. All of those things are more private than going through the court process. If somebody has a lot of money, then the guardian would also have a duty to have an investment plan.
Absolutely.
not risk it all.
No, as a fiduciary on somebody's behalf, it is your responsibility not to only protect it, but to use it in its best capacity. And so if the best situation is to put it in an investment account, at a higher risk, especially for a younger individual, then that is your responsibility. And the attorneys have great peers that they work with and can recommend.
Yeah, advisors. But you wouldn't want to leave it all in a no-interest checking account either, because there are safe ways to get some interest.
There are safe ways, and typically, the average guardianship has a checking account and a savings account. But then there are the higher ones that probably should have gotten a living trust before
Right.
this and had an investor already on board. And in those situations where it is a higher wealth award that we're working with, we look at the financial advisors that they've been working with, the CPAs, and we work directly with them to keep that individual's plan in place.
Yeah, or maybe just modify it as they get older or as their medical situation changes. Maybe their investment plan has to change as well.
Yeah, if they have IRAs and stuff, you still have to do the required minimum distributions for them. You have to file their taxes on their behalf. So you have to work with the IRS to have proper representation with the IRS.
Yeah. Okay, so you can see how difficult and complicated Texas guardianship law is. It's not required. You can do some planning in advance to help make sure this doesn't happen. Of course, there's no guarantee in life, but there is planning that can greatly improve the chances that you don't have to have this done.
Absolutely. We encourage anybody that's 18 or older to at least have a medical and statutory durable power of attorney. So the event that, a catastrophic event happens, somebody's there to take care of you. Somebody that you want to take care of you is there.
That's right. That's how you get your wants and needs to be legally enforceable. And even if you're healthy, accidents happen. If you drive on 35, I-10, 1604, or 410, you have to have those power of attorney documents.
Absolutely. Protect yourself.
Yeah, thank you for joining me today.
Thank you for having me.
You heard it here on Talk Law Radio about Texas guardianship. You can always find out more information by calling Marquardt Law Firm or going to marquardtlawfirm.com. If you want to suggest other topics about areas of law where you think there are hidden legal issues, email me at host@talklawradio.com. I'll talk to you later.
This has been Talk Law Radio with attorney Todd Marquardt, brought to you by the Marquardt Law Firm. You can learn more at marquardtlawfirm.com. And be sure to listen to the full Talk Law Radio show Saturday mornings at 11 on 9:30 a.m. The Answer.
Each week, attorney Todd Marquardt talks about the law. His mission with the Talk Law Radio show and podcast is to help you discover your legal issue blind spots. In the beginning, God had one law. Don't eat from the fruit of that tree. Then came the 10 Commandments. Now we have federal, state, and municipal lawmakers that won't stop creating new laws. Laws that might impact you without you knowing it. Listen to the show and drop a line on Facebook or email host@talklawradio.com and let the host know what you think of the show, the topics you want to hear, and whether you want to be a guest.